Imagine this scenario. You found your person.
Yeah.
The one.
Yeah.
You've built this whole life together, maybe 10 years, shared everything. And you decide, okay, it's time. Time for that big step. Marriage. You want the public recognition, the formal commitment, the whole I do thing. But then, bam, there's a problem. A really huge one. The law itself, the actual rules, say, nope, you can't.
Yeah.
That's the incredible challenge we're digging into today. What happens when love commitment slams right into the legal framework of a country? We're doing a deep dive into a truly landmark South African legal case, Minister of Home Affairs versus Fourie. It was decided back in December 2005. And look, this isn't just about dry legal arguments. It's really about how we define family, what equality means, human dignity. It fundamentally reshaped the society.
It really did.
Yeah.
And it's such a fascinating case because it put South Africa's entire legal system under a microscope, you could say. You had these really old common law traditions about marriage, right? Then you had existing laws, the statutes. And then clashing with all that was the new, very progressive South African Constitution. So the big question became, how do all these layers of law fit together? Especially when society's views are changing and you've got this fundamental right to equality written right there in the Constitution. Our mission today really is to unpack the key legal stuff, the arguments, and then they were powerful on all sides, how the court reasoned through it and, the impact. What did this decision actually do?
Okay, so let's ground this. Behind the legal case names, there are always real people. This specific story starts with Ms. Maria Adriana Fourie and Ms. Cecilia Johanna Banthus. They found each other, built this life together, like I said, over a decade, and they wanted to make it official, get married. But when they actually went to court, the Pretoria High Court, they just hit a wall.
Yeah, what they ran into was what you could call a sort of legal double whammy or double exclusion. First, you had the common law definition of marriage. For centuries, literally centuries, it was defined strictly as a union of one man with one woman to the exclusion of all others.
Very specific.
Very specific. Then the actual law governing marriages, the Marriage Act, well, it would kind of bake that definition in. Section 31 had forms and wording that only spoke of a lawful wife or husband.
Oh, okay.
So basically, neither the old traditions nor the current statute offered any pathway, any mechanism at all for a same-sex couple to marry. Legally, they just didn't fit.
And it's important to get the background here, right? In the South African context. Before democracy, in the apartheid era, same-sex relationships weren't just ignored. They were actually seen as immoral, sometimes even criminal. It was incredibly hostile territory. But then everything changed, or started to. 1994, the interim constitution comes in. And with it, this really powerful Bill of Rights, that was the game changer, especially Section 9.1 saying, everyone is equal before the law. And even more crucially, Section 9.3. That section explicitly banned unfair discrimination on specific grounds, including sexual orientation.
Exactly. So that set up the core constitutional question that was just staring everyone in the face. Did this exclusion from marriage, this silent obliteration, as the Constitutional Court later called it, did that deny same-sex couples equal protection? And did it count as unfair discrimination just because of their sexual orientation?
Right.
And if the answer was yes, then what? What's the right fix? Could the courts actually change the definition, or did they have to wait for Parliament to act? Big questions.
Huge questions. So, okay, the stakes are incredibly high. How did Fourie and Banthus actually start this legal battle? Where did they go first?
Well, like you said, they started the Pretoria High Court. They asked the court to declare that the law did recognize their right to marry and basically order the Minister of Home Affairs to register their marriage. But here's a really key point for how this played out initially. They didn't directly challenge the constitutionality of that common law definition or the Marriage Act itself. Not at that first attempt.
And I bet that was the crucial point for the High Court judge.
You got it. Judge Roux dismissed their application. He essentially said, look, the Marriage Act's wording, man and woman, husband and wife, it's mandatory, it's peremptory. So without them directly attacking those specific legal provisions on constitutional grounds, he felt he couldn't order the minister to do something that, on the face of it, looked unlawful according to the act as it stood.
Okay, so that door closes. What's the next move? Did they try to leapfrog straight to the top court?
That was the plan, yeah. They tried for a direct appeal to the Constitutional Court.
Yeah.
But maybe surprisingly, the Constitutional Court said no, not yet.
Really?
Justice Mosnike explained it. He said, look, this is a really complex and important issue. It touches on so many other areas of law. He mentioned labor law, insurance, tax. The feeling was that the Supreme Court of Appeal, the SCA, really needed to weigh in first.
Okay.
The Constitutional Court wanted the common law to develop coherently and harmoniously, as they put it, within the new constitutional framework. They felt the SCA's input would be of considerable importance.
Right. Makes sense to let the process unfold.
Sure.
So, okay, the case lands at the SCA, the Supreme Court of Appeal, and this was a big moment, wasn't it? All 5 judges agreed on the fundamental point. Excluding same-sex couples was unfair discrimination. But this is where it gets complicated because they didn't all agree on what to do about it.
Exactly right. Unity on the problem, division on the solution, the remedy. Justice Cameron wrote the majority judgment. And he was really forceful. He argued courts have an imperative duty, not just a choice, to develop the common law so it aligns with the Bill of Rights.
Yeah.
He pointed back to earlier equality cases, stuff that had already talked about dignity, inclusive moral citizenship for gay and lesbian people, the harm of discrimination.
Yeah.
He also stressed that the Constitution's idea of family wasn't fixed. It could be formed in different ways. But, and this was the key part of his ruling, Cameron felt that the specific wording in the Marriage Act, wife or husband, was just too rigid to reinterpret. He thought changing that, basically writing in new words like or spouse, that was a job for Parliament, not the courts. It required what lawyers call reading in.
Okay, I see the distinction.
So his immediate fix was to declare the common law definition changed. He said from now on, marriage is the union between 2 persons to the exclusion of all others for life.
2 persons. Okay.
But he also acknowledged that for actual civil marriages under the Act, the kind the state performs, same-sex couples would likely have to wait for Parliament to amend the Marriage Act or for someone to challenge the Act directly.
Interesting. So he changed the underlying principle but felt bound by the statute's wording for the practical side. What about the minority view at the SCA?
That was Justice Farlam. He completely agreed on the discrimination, the dignity violation, all of that. But he differed significantly on the remedy. He actually believed the Marriage Act could be sort of updated through interpretation. He thought you could read spouse, where it said wife or husband, to make it inclusive and constitutional. But interestingly, he favored suspending that change for 2 years. His reasoning was to give Parliament time. The South African Law Reform Commission had already done a lot of work and proposed different legislative options.
Right.
Farlam felt this gave Parliament the proper space to craft a comprehensive solution, rather than just a judicial quick fix.
Okay, so the SCA agrees there's discrimination, but offers different paths forward. Unsurprisingly, nobody was completely happy. The state wasn't happy. The applicants weren't fully happy, which led to appeals going back up to the Constitutional Court. And this brings in the second case we mentioned, the Lesbian and Gay Equality Project 1.
Exactly. That case was crucial because they went straight for the jugular, constitutionally speaking. They explicitly challenged both the old common law definition and that specific problematic bit, Section 31, of the Marriage Act. And this time, the Constitutional Court said, okay, yes, we'll hear the Equality Project directly. They saw that the issues in the Fourie appeal and the Equality Project case were, as they put it, inextricably intertwined.
Made sense to join them.
Exactly. No new facts were really needed, and hearing them together would avoid dealing with the problem in bits and pieces, what they called piecemeal adjudication. So now, the main event, the highest court, tackling the whole issue head on.
Okay, so the stage is set. Highest court, both cases combined. What were the core arguments they wrestled with? How did the Constitutional Court break it all down?
Right. The court laid out its reasoning really systematically. They started by confirming, yes, this exclusion is unfair discrimination and denies equal protection. They acknowledged that, okay, the right to marry isn't spelled out word for word in the Bill of Rights. But they said the Constitution's fundamental values, human dignity, equality, freedom, these absolutely prohibit the state from arbitrarily interfering with your right to choose a partner, marry, and form a family. And they really built on their own history, their precedents. They referred back to previous rulings that had already talked about the seriously negative impact of discrimination against gay and lesbian people. They highlighted their status as a permanent minority and how discrimination hits hard at their dignity, personhood, and identity. And they reiterated that the idea of family in the Constitution is flexible. It can be formed in lots of different ways.
You mentioned that Latin phrase earlier, the consortium. How did that play in?
Yes, the consortium omnis vitae. It basically means the total partnership, the physical, moral, and spiritual community of life that marriage represents. The court made the point very clearly. Same-sex partners are as capable as heterosexual spouses of creating that kind of deep, supportive bond. They provide support, they build homes, they raise families.
Right.
And the court used some really powerful language here. They talked about the sting of discrimination. They said the exclusion sends a message that same-sex relationships are somehow inferior, that gay and lesbian people do not have the inherent dignity and are not worthy of the human respect possessed by and accorded to heterosexuals.
Wow, strong words.
Incredibly strong. They said this denial hits at the very foundation of the Constitution, equality and dignity.
So it wasn't about forcing everyone into the same box, but demanding equal respect for different kinds of loving relationships.
Precisely. The judgment explicitly says equality doesn't mean sameness. It means equal concern and respect across difference. The Constitution, they said, acknowledges the variability of human beings, it affirms the right to be different, and it actually celebrates the diversity of the nation.
That's quite profound.
It is. And they concluded that to penalize people simply for who they are, for their orientation, is profoundly disrespectful. Then they also looked at the practical side, the significance of marriage in society.
Yeah.
It's not just a private affair, right?
Yeah.
It's a public, law-governed, and state-regulated domain. And that comes with a whole raft of legal consequences.
Yeah, like taxes, inheritance.
Exactly. Reciprocal duties of support between spouses, property rights, parental rights and duties, inheritance, medical aid benefits, insurance, tax advantages. The list goes on and on. So excluding same-sex couples forced them into this legal blankness. It denied them choice, denied them self-definition. This wasn't, as the court put it, some small and tangential inconvenience.
No kidding.
So the final conclusion on this point was stark. The silent obliteration of same-sex couples by both the common law and the Marriage Act was in direct conflict with the Constitution.
Okay, so the court establishes the discrimination is real, it's profound, it violates the Constitution. What about the arguments against changing the law? What did the state and other groups like Doctors for Life or the Marriage Alliance argue to try justify keeping things as they were?
Right. The court then had to address those counterarguments, and they tackled them one by one. First, there was the procreation argument, the idea that the essential purpose or definition of marriage is linked to having children. The court flatly rejected this. They called it deeply demeaning. What about couples who can't have children or choose not to? Older couples, adoptive parents. Procreation just isn't the defining feature of marriage in law or reality.
Makes sense. What else?
Second big one, the respect for religion argument. The claim was that recognizing same-sex marriage would trample on religious freedom or fundamentally change marriage as a religious institution. Here, the court drew a really clear line between secular marriage law and religious beliefs or practices.
The separation.
Exactly.
That's it.
They said religious beliefs, no matter how deeply held, cannot influence what the Constitution dictates for secular law that applies to everyone. They emphasize that the Constitution does protect religious freedoms. Ministers absolutely have the right not to solemnize a marriage that goes against their faith's tenets.
Okay.
But, crucially, that protection for religious practice does not prevent the state from recognizing same-sex civil marriages for everyone else under the law. Third, they looked at international law. Some argued that global documents, like the Universal Declaration of Human Rights, only talk about marriage between men and women. The court's take was interesting. They said those provisions were likely descriptive of an assumed reality at the time they were written, rather than setting a prescriptive normative structure for all time.
So reflecting the past, not dictating the future.
Kind of. And they also made a key distinction. Unlike maybe some international bodies, the South African Constitution explicitly prohibits discrimination based on sexual orientation. South Africa's own supreme law was the deciding factor. And the last main argument was this family law pluralism idea. The Constitution has a section, 15.3, that allows Parliament to pass laws recognizing marriages based on religious or traditional systems alongside civil marriage. So the argument was, well, maybe same-sex unions should be recognized through a separate law like that, created by Parliament outside the main Marriage Act.
Like a separate category.
Oh, yeah. But the court said, hold on, Section 15.3 is permissive, it allows for diversity, it's not mandatory, it doesn't create a barrier preventing same-sex couples from claiming the right to be included within the existing institution of marriage itself. It wasn't meant to sideline them.
Got it. So after knocking down all those justifications, what was the final word on whether the discrimination could be excused or justified under the Constitution's limitation clause?
The finding was clear. Absolutely no justification. The court found that arguments about undermining marriage or causing religious offense were, again, profoundly demeaning. They said these arguments were ultimately rooted in prejudice, and prejudice can never justify unfair discrimination.
Mm-hmm.
They also pointed out the obvious. Letting same-sex couples marry doesn't stop heterosexual couples from marrying in any way they choose, including according to their religious beliefs. It takes nothing away from anyone else.
Okay. So discrimination established, no justification found. The big question remaining is the remedy. What's the solution? What did the Constitutional Court decide was the just and equitable way forward?
This is where it gets really interesting in terms of judicial philosophy. The majority decision written by Justice Sachs did two main things. First, it declared both the common law definition of marriage and Section 31 of the Marriage Act inconsistent with the Constitution and invalid because they failed to include same-sex couples.
Okay, so struck them down.
Struck them down. However, and this is the crucial twist, the court then suspended that declaration of invalidity for 12 months.
Suspended? Why? Wait, if it's unconstitutional, why not fix it immediately?
That was exactly the debate. Justice Sachs laid out several reasons for the suspension. First, public consultation. He noted the Law Reform Commission had already done extensive public engagement on domestic partnerships and was close to proposing legislation. Let that process finish. Second, the role of Parliament. He argued that marriage deals with legal status, and Parliament is generally well-suited to figure out the best way to legislate changes to status, to bring same-sex couples in from the legal cold. Parliament should be the front line.
Okay, deference to the legislature.
Somewhat, yes. He argued a comprehensive legislative solution would provide more enduring and stable legislative appreciation for these relationships, rather than just a temporary court-ordered fix that might feel a bit twilight and impermanent. Third, avoiding what he called equality of the graveyard. They wanted to make sure the result was everyone having the right to marry, not accidentally striking down marriage for everyone by invalidating the whole act immediately. Ensure equality of the vineyard, as he poetically put it.
Right, level up, don't level down.
Exactly. And finally, crucially, avoiding a separate but equal trap. Parliament needed time to craft a solution that was truly and manifestly respectful of dignity, not just offering a parallel system that might create new forms of marginalization.
So Parliament gets a year. But what was the backstop? What if they didn't act in time?
The safety net. That was the critical contingency clause in the order. It stated very clearly, if Parliament failed to fix the problem within those 12 months, then Section 3001 of the Marriage Act would automatically be read as if it included the words or spouse after or husband.
So the change would happen one way or another.
Precisely. You put the pressure on Parliament, but guaranteed the outcome if they failed to deliver.
Okay, so that was the majority view. Suspend the order, give Parliament a deadline, but have an automatic fix ready. But you mentioned dissent. Not everyone agreed with this timing.
That's right. Justice O'Regan wrote a powerful dissent, but only on the remedy part. She completely agreed the exclusion was unconstitutional. But she argued strongly for immediate relief, no suspension.
Why? What was her reasoning?
She made several points. First, the basic principle: successful litigants should normally get the relief they asked for, right then and there. Second, she emphasized the court's duty to make sure the common law aligns with the Constitution now, not later. She also felt the choices Parliament actually had were quite limited anyway, so an immediate order wouldn't cause massive uncertainty. And she pushed back on using the separation of powers idea as a reason for the court to avoid its duty to provide appropriate relief when a right has been violated. An immediate order, she argued, wouldn't undermine the institution of marriage at all. Instead, it would immediately start fostering that society based on dignity and respect for difference that the Constitution envisions.
Wow. So two very different views on the how and when of fixing the problem, even though they agreed on the what. This decision clearly had enormous significance. How did it practically reshape things? What was the immediate fallout?
It was absolutely groundbreaking. You can't overstate it. It fundamentally changed the legal definition of marriage in South Africa, pushing it decisively towards equality. The direct result? Parliament got the message, they had their deadline. And they did act. In 2006, before the 12 months were up, they passed the Civil Union Act.
So that's where that came from.
Yes. That act specifically allows for both same-sex and opposite-sex couples to enter into either a marriage or a civil partnership, giving them the same legal consequences. So the case directly led to legislative change. It also powerfully underlined the judiciary's role as a guardian of the Constitution, willing to hold Parliament accountable even on really contentious social issues.
It's quite something when you step back and think about all the competing forces in this case. You have the very personal human desire for love and recognition. You have centuries of legal tradition and definition. You have deeply held religious beliefs on one side. And then you have these powerful, relatively new constitutional principles of equality and dignity on the other. It's like a snapshot of societal growing pains.
Absolutely. And maybe the lasting thought here, the thing this case really makes you ponder, is that ongoing tension, that push and pull between tradition and transformation within the law. How does the society navigate that? How do you balance beliefs that are genuinely deeply held by many with this constitutional imperative to create a space that is truly inclusive, truly equal for everyone? It makes you wonder, how do you see those same tensions playing out today? In other legal debates, other social issues, it's a question that doesn't really go away, does it?
Definitely food for thought. Powerful questions for you, the listener, to consider. We hope you'll continue your own deep dive into how law doesn't just reflect society, but actively shapes it, sometimes dramatically.